Well, welcome everyone to tonight's program. This is what we call a rapid response program in the Constitutional Law Center, where recent Supreme Court decisions or other developments that are of interest to the constitutional law world. We try to get together members of our faculties or elsewhere to provide some rapid response and give our audience a chance to ask questions and participate. And last week, as most of you know, the Supreme Court decided the two cases having to do with the Biden administration's vaccine mandates. Are probably more accurate to say that these are vaccine or testing mandates, at least in the case of the workplace. Two different cases, two different statutory schemes, one of them under the Occupational Safety and Health Act, OSHA, on all employers of 100 or more workers, and the other imposed through the healthcare bureaucracy on healthcare workers. I think a lot of people expected the two cases to come out, rise and fall together. Both of them are about vaccine mandates imposed by the executive branch. But in fact, the court decided them differently. With one case, the OSHA case, 6-3, holding that the administration lacked authority to impose the vaccine mandate, and the other case, 5-4, where the Supreme Court majority held that the administration did have authority to impose the mandate in the healthcare field. Most of the justices voted either for or against both. But Chief Justice Roberts and Justice Kavanaugh voted with the majority in both cases, that is, against authority under OSHA and in favor of authority under the healthcare scheme. And I'm honored to introduce and welcome our colleague Bill Gould tonight. I think this is his first Constitutional Law Center program. Bill is one of our, are you the senior member of the faculty now?
I don't think so, not quite. No, there are a few who have got me beat.
Close to it. I mean, one of our most distinguished faculty members. Bill has been on the Stanford Law School faculty since 1971. I was in high school. I think of myself as one of the older folks around here, but I was in high school when he started, and Bernie said she wasn't even born yet. So that gives you some sense. So Bill is one of the leading figures in American labor law. He served for a number of years in the 1990s as chair of the National Labor Relations Board. He was also chair of the California Agricultural Labor Relations Board. And excuse me for my cough. This is not COVID, according to all the testing, but I do have a chest cough. So he teaches labor law and related courses here at the law school, and it is a real pleasure to welcome him tonight. And he's going to be kicking off because he's the real expert of the three of us on this topic. Bernadette Meyler is known to many of you. She's one of the teaching one of the three basic con law courses this year, and because of the constitutional dimensions here, the delegation doctrine and so forth, she is going to present her point of view as well. So I hope we have some difference of opinion and we can go at it. So Bill, you have the floor.
Okay, thank you, Michael. I'll try to keep my remarks to about somewhere between 10 and 15 minutes. Is that acceptable to you? On this business of whether the vaccine programs were at issue, of course, the Supreme Court in the case involving the OSHA, which would cover about 84 million workers under the Secretary of Labor's authority to promulgate under the OSHA statute standards relating to health and safety. The court characterized it as a vaccine case, but of course, as you correctly characterized it, Michael, it was a vaccine and testing case. And the second case, the HEW case, which carried the day with a majority of the justices, was a vaccine case with medical and religious exemptions. The real question, I think, in essence, was, did OSHA have authority to fashion rules relating to this kind of disease, which is not purely workplace, but which affects the entire community? And the Supreme Court held by 6-3 that OSHA did not authorize the Secretary of Labor to, Congress had not authorized the Secretary of Labor to so have proceeded, that it was too broad. It was not strictly occupational. This despite the fact that Congress itself prodded the OSHA to fashion rules with regard to HIV, blood pathogen regulation in connection with HIV, which of course also is not purely a workplace matter, but and indeed less so, because this disease is so easily transmissible through air, and an airborne disease. OSHA has also regulated the construction industry and made sure that workers only can use one cup so as to not pass infectious diseases. It's regulated farm workers and with regard to conditions in the environment which are not peculiar to the workplace. And most important of all, the American Rescue Plan Act of 2021, when this very Congress, which is sitting now, authorized the money to be spent for the pandemic, which was by OSHA itself. It allocated monies to OSHA and didn't say to OSHA, oh, please make sure you don't expend any monies on matters that are peculiar to the workplace. In fact, it couldn't, because we know that the virus is not peculiar to the workplace. So I don't think there's too much doubt that the court got it wrong big time in this 6-3 opinion, which was correct, which was anticipated with the tone of the, when you look at the tone of the oral argument. As Michael has said, 5-4, the vaccine testing under for recipients of Medicare and Medicaid was upheld by a 5-4 vote, amazingly enough. What was at issue here, of course, was the ability of OSHA not only to regulate, but to do so through a so-called emergency temporary standard, which would bypass the regular notice and comment period required by the Administrative Procedure Act for the next 6 months. It may do so under the statute where the situation is a grave threat to safety and health, and where the effort undertaken is necessary to combat the grave threat. The judges, the majority of the court, with regard to OSHA, seem to think that something that, or at least Justice Gorsuch and Alito and Thomas tried to impute to the majority opinion, they didn't pick this up explicitly, a so-called major questions doctrine, which is that if an agency does something extraordinary, of course, there's no doubt that the agency did something extraordinary here. We had never seen anything like this in the 52-year history of the agency. Then the court could set aside the decision as beyond the reasonable expectation of the Congress at the time that it enacted the statute, because it constituted an enormous expansion, in the words of some of the opinions. This is a sort of a new judge-made, judge-crafted doctrine, which is designed to, I fear, interfere with the verdict of the people's representatives as reflected in statutes like the Occupational Health and Safety Act, and to reverse what the public has in fact established through statute. I saw, Michael's referred to the time I was in Washington. I saw frequently in Washington grave dissatisfaction with with the statute that I administered, the National Labor Relations Act, much of the legislation that was passed between the 30s and the 70s. The judges, many of the new judges don't like this legislation, and they are fearful of what they call, we saw this in particular in the Fifth Circuit case in the OSHA ruling, the administrative state. These appointed figures who are doing secretive things deep down in the bowels of the federal bureaucracy, and the Fifth Circuit picked up on this and picked up on another thing that emerged more explicitly in the oral argument itself, and that is that really this disease is not that serious. As Justice Gorsuch said in oral argument, it's really like the flu. You don't purport to regulate the flu, but we lose, and there was a controversy that emerged as to precisely what he did say. The transcript said, he said, we lose hundreds of thousands of workers every year through the flu. That's false. The transcript was revised so as to say hundreds, thousands of workers. The other major objective to what the Biden administration was attempting to do to provide some kind of safeguard against this was to, the other argument was, as articulated more in the oral argument by Chief Justice Roberts, that this is really a matter of states' rights. This was something that the Fifth Circuit had also picked up on, that this was not a subject for the national government, but rather the state government, and that the national government had no authority in this area. I just talked to my students the past couple of days about Jones and Laughlin, NLRB against Jones and Laughlin from 1937, which held that Congress may regulate subject matter in interstate commerce involving employment conditions. This would come as a great surprise to those who accept the idea of stare decisis in some fashion. And I think that all modern labor and employment law that has emerged during the time of congressional regulation. So this was maybe I better stop by simply concluding that this was a very sad day for the court. As the dissent said quite properly, the real question was, who decides? The people's representatives or these judges who think they know more about the disease, the way to regulate the disease, than those who have elected their representatives and the appointees who have been provided by by the appointments process, this new administrative state. This was a modest effort by the president to combat this remarkable, unprecedented disease, which we have not seen anything like, not only during the period of this 52 years that OSHA has been in effect. It is the Safety and Health Act together, not just safety in the workplace, but the health of the workers, and certainly not something that we've seen in the past century.
Thank you very much, Bill. I'm going to speak next. I have nowhere near the expertise that Bill has in this. I just am a Supreme Court observer, not a labor law or OSHA expert. I agree with a great deal of what Bill said. I think this is clearly within the federal power, and I agree with a lot of it. I also think many of the justices on both sides, by the way, showed remarkable ignorance about facts about the disease. I'm glad that they didn't decide this on policy grounds. They're not an expert agency, and they're no more expert than I am, which is not one whit. But I would like to clarify what I understand the reasoning was of the majority, and why I think that it is at least within the range of reasonable decision. And the bedrock principle here is not federalism, I don't think. The bedrock principle is that the executive branch cannot impose coercive regulations on people and the economy on anywhere except by statutory authority. That the president isn't given by the Constitution the right to make law. The Congress has that. And so the president has to have statutory authority to act. And that doesn't mean that you look at a statute and sort of, twist the words or pound it into shape, or, like as if it's a ball of Play-Doh and you're trying to get it into. And the question is whether this is really within the scope of the authority that Congress, the representatives of the people, have imparted. And OSHA is fundamentally a statute regulating workplace hazards. And COVID is not a workplace. I mean, it's an everything hazard. Bill is completely right when he says that it is a hazard in the workplace, but it's no more a hazard in the workplace than it is anywhere else. You can catch it anywhere. Right now, I think there are some workplaces which would present particular dangers of COVID. And I think if the Department of Labor were to have narrowly tailored regulations directed at those places that are particularly hazardous, that they might very well pass muster. But this is a scattershot regulation that applies to all workplaces over 100 employees, including places that are probably considerably safer than the rest of life. So, it applies to delivery truck drivers. It applies to the person who's working all by himself or herself in the mailroom. It applies to every worker except those who are entirely working remotely from their homes. And we know, I think all you have to do is to see is to not put on blinders, but actually to see the reality of the situation. We know that the purpose of this rule was to use the leverage of OSHA in order to coerce workers into getting vaccinated, right? If you don't get vaccinated or tested regularly, and the testing is is at your own expense and relatively frequent, and it has to be on your own time. So if you don't get vaccinated or do that kind of testing, you can't work. Basically, it's holding your ability to be a worker, to earn a living, hostage to your getting vaccinated. And I have no particular problem with vaccination mandates in general, but the question is the executive branch empowered by statute to do that? And we know that was the actual reasoning of the administration, because they said so. You know, Ron Klein actually says this. This is a workaround. He says because they don't have the straightforward authority to require people to get vaccinated, they are using using the pretext of workplace regulation as a way to regulate workers. Well, OSHA is about regulating employers to get the employers to have safe workplaces. It is not about using employers as enforcement agents for a general public health requirement for people who happen to be workers. I think, you know, you may agree with that or disagree with that, but I think that is the logic of the majority opinion in the Supreme Court, and it doesn't seem to me to be completely off base. And this is in contrast to the healthcare situation, which is an entirely different statutory scheme involving a very different kind of workplace. So, you know, hospitals and clinics and healthcare places are vectors. I mean, they are special vectors for the spread of COVID. The statistics show that you know, many more people catch COVID when they go into the hospital, you know, without it than in most other circumstances. So it's both more dangerous, but also vulnerable people. You have sick people. You have people with comorbidities. You have, and so it's a place where we need to be particularly careful, and to make sure that hospitals are a safe place to get treated is surely, at least I think plausibly, within the scope of the statutory authority given the healthcare regulators. So on the whole, I don't view this as like some sort of unprincipled compromise, split the baby. I think what the court did with at least the two justices who went in with the majority in both cases did was to look you know, carefully and searchingly at the two statutory schemes, realizing that they have different scope and different application, and it resulted in a different decision in the two cases.
So I think I will take over here. Both Bill and Michael have set the stage and said a lot of the things that I want to comment on, but I want to kind of pick up on a couple of points that they raised. I tend to agree with Bill that I'm disturbed by the reasoning of the per curiam in the case, especially the OSHA case. But at the same time, I do think there is a principled way of reconciling the two cases along the lines that Michael suggested. And I want to explain why I'm still troubled by the reasoning in the per curiam opinion in the OSHA case. So one thing that Michael said, or towards the end, was that OSHA is supposed to be getting employers to regulate unsafe products or chemicals or unsafe elements and hazards in the workplace. It's also intended to protect employees. And the provision that's at issue in the OSHA case requires OSHA to issue an emergency temporary standard to take immediate effect if it determines that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful, or from new hazards, which could be COVID, and B, that such emergency standard is necessary to protect employees from such danger. So if we think about that context and we think about the fact that people are going into work every day and are forced to potentially confront other coworkers who are not taking precautions against COVID and aren't going to be protecting the worker who could actually have a number of underlying conditions that make it unsafe for them to be present with someone who might be more contagious for COVID, I think we have some ground for this regulation that's based actually in the health and safety of workers in any workplace. So I think that both Bill and Michael have explained that the distinction that the per curiam and the Gorsuch opinion are drawing in the OSHA case has to do with the fact that this isn't a regulation that's somehow specifically about workplace health, but instead seems to be a general public health measure. But I think that if we take the employee perspective, certainly most Americans are employees, but that doesn't rule out the fact that they may be subject to greater risk in the workplace due to COVID. Now, I think I want to also point out and follow up on one thing that Bill pointed out, which was that in the Gorsuch concurrence in this case, he mentions this idea of the major questions doctrine, but the per curiam also raises this notion that there's a rule that Congress has to make a clear statement whenever it, quote, wishes to assign to an executive agency decisions of vast economic and political significance. And this comes out of a case also last year dealing with the eviction moratorium. And ultimately, they are quoting from an opinion written a while ago by Justice Scalia. So here, there's an idea that there shouldn't be this kind of excessive delegation of authority to the agencies by Congress, that Congress has to be extremely clear about whatever it's allowing agencies to do and allowing the executive branch to do. Now, I want to suggest that in a world where legislative gridlock is just pervasive and where we can't really get many legislative pronouncements on a lot of issues, that what the effect of that kind of clear statement rule is basically to say that there won't be federal regulation in a lot of areas. So that if we require Congress to step in and to jump in every time there's a new circumstance that might require a slightly different formulation of a rule, then that's going to mean that we just don't get regulation. So I think fundamentally, this opinion is really ultimately a kind of deregulatory opinion in effect. And I think this gets into the question of workplaces that pose a special danger or don't pose a special danger. And I think, as Michael is saying, that this is why it's not that hard actually to reconcile the opinion in the OSHA case with, or the decision in the OSHA case with the decision in the Medicare and Medicaid case, because there's a distinction that the opinion draws in the OSHA case between just the workplace in general and occupations that are particularly dangerous. So at one point in the per curiam opinion, they say it draws no distinctions based on industry or risk of exposure to COVID-19. Thus, most lifeguards and linemen face the same regulations as do medics and meatpackers. Another point, there's the idea that where the virus poses a special danger because of the particular features of an employee's job or workplace, targeted regulations are plainly permissible. We do not doubt, for example, that OSHA could regulate researchers who work with the COVID-19 virus. So too could OSHA regulate risks associated with working in particularly crowded or cramped environments. So there's this assessment that the court is engaging in about the relative risk of workplaces. Now, I've recently been teaching a lot of cases in the history of the commerce power, and especially the cases that occurred around the time of the switch in time that saved the nine, so-called, which preceded the case that Bill referenced, the Jones and Laughlin Steel case, where there's a recognition of, or a much more permissive allowance given to Congress for regulation in the aftermath of the potential court packing historians say that it wasn't caused by that. But anyway, it's around the same time, and in relation to the political branch's pressure during the New Deal on the court to change its approach and have a less restrictive approach to evaluating federal legislation. And before that, so looking at some of the cases that preceded that switch in time, a lot of those tend to draw these categorical distinctions. And they tend to, so for example, a case called Lochner, which you may be familiar with, which brings up a kind of substantive due process defense of individual contract against efforts to regulate wages and hours. In that case, the court says, well, the occupation of a baker isn't especially dangerous. We don't need these kinds of regulations in bakeries. We might need them for other contexts like mining, but we don't need them in bakeries. And similarly, going the other way, the court allows in Mueller against Oregon workplace regulations only because they pertain to women who the court thought needed special protection. So I see these kinds of interventions by the court and categorical distinctions that they're drawing between kinds of workplaces as maybe overstepping their proper role in the judicial function, right? So these seem to me to be more kinds of distinctions that should be thought about by Congress or should be thought about by regulatory agencies rather than by the court in drawing these lines. And I think this gets back to, what both Bill and Michael said about, the court isn't an expert at figuring out, things about COVID or about, various kinds of occupations. They're experts at the Constitution, at judging, at the legal arena, but not necessarily at these very specific fact-based determinations. So I think this gets into the other question that also Bill and Michael raised, I think, which is who decides. So it's interesting to me that in both the Gorsuch opinion and the Sotomayor opinion, as a student pointed out to me, in fact, they both reference this question of who decides. And for Gorsuch, it's a question of whether Congress and elected representatives decide or an unelected agency. But as Sotomayor and the other dissenters are trying to point out, it's actually by stepping in, the court is deciding rather than any representative of an elected body. So this, to me, I feel that the sets of distinctions that they're trying to draw in this case, while it does help to reconcile the two cases involving the so-called vaccine mandate formally, are unsatisfying because they seem to me to be kind of reinstating these formalistic distinctions and this interventionist approach that the court had eschewed for a long time in thinking about matters of public policy and public regulation. So thanks so much.
Can I say anything?
Oh yes, please go ahead, Bill.
Let me just make a couple of very quick points. One is on the business of, because this comes up in connection with both what Michael and Bernadette say, that of course the assumption is in a statute like this, as Bernadette said, that employees, the workplace is central, employees come together, they're going to have contact, and particularly with regard to a disease that is transmissible in this fashion, it's important to regulate the workplace. But many groups of workers were excluded from this. Landscape workers, as well as remote workers, people who worked outside, were put beyond the rule. Now, the court obviously thought that OSHA, acting pursuant to not the executive branch on its own, but a 1970 statute passed by Congress, was they made the wrong judgment. That the court had a different view, and it regarded itself as the expert. Well, and I that's a. I had a dean the first time I taught law who said to me, always tell it to them twice. And I just want to come back to the fact that Michael, not the executive branch, the 1970 statute, which the court superimposed this clear statement, artificial requirement on, under which, this is where I want to say it twice, on at least 4 occasions, Congress, sometimes, with regard to HIV and the regulation of blood pathogens, Congress was so mad with the inability of OSHA to get this resolved that it gave it a deadline and said, if you don't resolve it by a particular point, we're going to resolve it for you. Now, this is not a Congress that thought that HIV was peculiarly a workplace disease. And indeed, the idea that OSHA could regulate this is far beyond, is far more attenuated than this particular disease, which is transmitted by air. And of course, again, the American Rescue Plan, where Congress, in the context of this pandemic, gave money directly to OSHA and said, you combat it. And you have, I regret that the dissent didn't make enough of this. I think Judge Stranch and her opinion and the Sixth Circuit, a brilliant opinion, which just looked at this matter thoroughly and exhaustively, did. I better shut up because I see the clock moving.
Thank you. We do have lots of excellent questions from our audience, and you should feel free to continue submitting them in the chat. I'm just going to dive right in, and of course, the panelists should feel free to weave in other questions as they see fit. So, you were all reflecting for a while on the distinctions between the two opinions, and one of the questions from our audience really focuses in on the difference between the two cases. And so I'll put this question to you. So this audience member is asking, sort of references Professor McConnell's comments, noting that you might be drawing a line between high-risk occupations and other occupations, and that the idea that the vaccine mandate might be a legitimate regulation in the former case, but not in the latter. And this audience member says, in light of what we know about how COVID spreads, is this really the best line to draw between the kind of occupations that we're talking about? And given that we know the likelihood of contracting the virus is highly correlated with how long you're exposed, it seems that someone working in person would be more likely to have extended exposure to COVID than someone working from home. And if that's true, then COVID would be a greater hazard in the workplace than in other places. So would that change your opinion, Professor McConnell, or do you still think that the mandate exceeds the agency's authority? And do other folks perhaps want to weigh in on this question as well?
Well, I just reiterate, I don't think the question is one of policy. Is this a good idea or not? The question is whether it's within a statutory authority. And if the agency is designed to regulate workplace hazards, then, and what we have here is a public health measure that applies pretty much across the board everywhere. I think the court was concerned that this was simply using, the executive branch was simply, taking advantage of levers that it had over workers through their employers to accomplish what is essentially a public health measure, and not really the classic area for OSHA regulation.
Well, what makes this case difficult, of course, is the fact that there is a slight ring of truth in aspects of what Michael says, and that is that clearly, as we know from just what the president said today, and he said it countless times, the idea is to encourage vaccination. And the president, the OSHA clearly dove into this the way they did, involving 84 million workers, figuring that not only would they regulate and encourage vaccination, although vaccination wasn't the mandate, but that you would set an environment, and the big company, look, a lot of the big companies, AT&T, Tyson, a large number of companies have devised these rules themselves, and they were looking for. There are others who are looking for cover, and you know, the one of the things that we haven't talked about at all in this discussion that figured in the back and forth was that everyone will resign and go away, but there wasn't. You know, in the Houston Methodist case, where which represents the first case involving an employer's ability on its own to require vaccination, this hasn't happened. Although it was said that it would, and it hasn't apparently happened with these big companies who would have been part of the agenda.
Thank you. Another one of our audience members touches on something that you all brought up, which is the major questions doctrine and sort of what these opinions mean for the future of that doctrine and how it might be developing. The audience member lays out two different versions of the major questions doctrine, one that the audience member thinks of as more radical in the OSHA case, suggesting that agencies can't be deemed to have delegated authority over questions of great economic import, even if the statutory language seems to support it. And this view, to the audience member's mind, would deconstruct the administrative state. And the second interpretation of the major questions doctrine that seems to be on the table is the one that Chief Justice Roberts developed in the Obamacare case, where he declined to apply Chevron deference. So could you weigh in on the future and current interpretation of this doctrine and how these cases might inform that?
Well, I see the major questions doctrine as being another sort of canon or rule of statutory interpretation. And I don't think this is designed to tie Congress's hands, and I don't think it does. I think it's designed to for courts to be able to interpret what Congress has actually done. And the idea here, the common sense of the doctrine, is that when it comes to really significant economic or social programs, that if Congress just doesn't tend to overlook big things. They might, little things, they may just have not even thought about it. But when it comes to the big things, if Congress intended the agency to have that kind of massive, important, broad-ranging discretion, they'd have said so. And when they don't say so, when the language of the statute is at best ambiguous, then it just seems likely that that is not something that was within their contemplation.
Michael, you know that there was no big thing that could ever be within the contemplation of anybody at any point during this statute. I mean, it's only in recent years, and Bush contributed to some extent to this. President Obama began to focus upon the threat that these new viruses would pose. You referred to how old I am, and I have to say that I had two parents who lived through the influenza of 1918. Now, I frankly, many times as this has unfolded, I wish that they were here I could discuss this with them. I never heard anything about this. This was not within the potential concrete comprehension of anyone at the time that this statute was enacted. No way. And the only thing we can do is look at whether this is just a poor, enfeebled agency which is only concerned with the hard hats and protecting workers against flying objects around the plant, or whether it's concerned with disease as it was with regard to construction workers, farm workers, and HIV people. Whether it's concerned with this type of subject matter, surely, yes, the Congress never thought of this. None of us ever thought of this. Nobody thought of it. But now we have a statute that's on the books that deals with this subject matter. And the question becomes, are we going to hobble it through clear statement through which de facto whatever Congress is in power at a particular time can refuse to ratify or not ratify? Or, you know, when I was in Washington, the majority of the Congress really, I think, would have liked to have repealed the National Labor Relations Act. That's the way they came across to me, but they weren't able to, or they didn't want to, even though they did many things that indicated that they did. This is really a surrogate for the inaction or unwillingness or inability of Congress to turn back the civilized developments of those 40 years between the 30s and the 70s.
Just adding a little bit, I think that part of the question is sort of how adaptive we want our statutes to be, right? So if this is a rule of statutory interpretation, then how is it dealing with new big things that come up, as Bill is expressing? And then also, I think going back to legislative gridlock, that if we're asking Congress to kind of revisit in light of each new big thing, that may not be feasible because of the difficulty of getting any kind of framework legislation passed. So, I think if we think about these framework statutes and the way that they're adapting over time through administrative interpretation, then that's one model. And then I think the major questions doctrine is sort of posing another model of how we want to think about the relation between statutes and their evolution.
Great, thank you so much. I want to share a question that I received over email, which echoes another question that's in the chat about the interpretive method that was used in the majority opinion. And the question turns on the view that at least four of the justices in the per curiam describe themselves as textualists, but that nonetheless, in the opinion in the OSHA case, it doesn't take a textualist approach, and instead focuses on the broad purposes of the statute and how OSHA has used its authority in the past. Can you speculate about why the majority failed to grapple with the text?
I think we can do more than speculate. Look, we have a majority of the Supreme Court today that is inhospitable, that doesn't like these laws that have been enacted between the 30s and the 70s, and once in a while they stray from this. It is true that, as I was saying to my class this morning, when you look at the sexual orientation decision by Gorsuch a couple of years ago, once in a while they follow a doctrine to its logical conclusion, which I'm sure Gorsuch's critics thought was insane, was absurd, and but basically, again, you see a lot of this in oral argument. Thomas and Alito were just fascinated by the fact that that young people who are unvaccinated are less likely to die than older people who are vaccinated, suggesting, although they didn't pick up this particular idea in the opinion, that that's a way that would be for the court, for OSHA to be more particular. By the way, I don't think there's a way, contrary to what the court says in its own opinion, for OSHA to be more particularized in this subject matter. They can't say that, oh no, we know that meatpacking workers are side by side, and that there's a lot of COVID in that particular facility because it's not unique to the workplace. And they maintain, they apparently felt that they had to say that this was unique to the workplace. They will say a lot of things. They do not like this legislation.
I would say, for me, the question is sort of which textualism, because the opinion does say, you know, we are finding the textual source in the organic act of the agency, which says that OSHA is charged with regulating occupational hazards, right? So they're taking that as determinative instead of the sort of text of the emergency provision. And then also, as Michael was saying, there, you know, he interprets the major questions doctrine as a doctrine of statutory interpretation, right? So, so I think that there, you know, I think one of the lessons is that there are different ways of thinking about textualism, right? That textualism doesn't itself determine the outcome in a particular case. Which textualism is more important, I think, than, you know, simply saying that you're a textualist or not.
I think it's easy to caricature textualism, and you know, some of the self-professed textualists, I think, almost invite caricature because they, you know, they act as if text is all. But I think if you look at the basic, the texts of textualism, that is the people who expound the theory, you know, text is always in context, and it is always permissible when you're faced with ambiguous language, to look at the, you know, broad purposes as a means of understanding what the words mean. I think that what textualists reject is the idea that they can abandon the language altogether and substitute their own understanding of the purposes of the statute for it. But I don't think that's what the court did here. What the court did is I think Bernie just was saying, is that you know, they look at some of the basic language of the statute itself, you know, maybe not the emergency provision so much, but the basic language of the statute, to see, you know, what is the scope of authority of this agency. And that doesn't seem to me to be contrary to at least a realistic understanding of what textualism is about.
Thanks. Since we're toward the end of our hour, I want to ask you, sort of looking forward, a couple of audience members asked, you know, what might happen next? Will OSHA try to take another stab at perhaps narrower regulations as suggested by the court that might pass muster? And related, in terms of a forward-looking question, how does the rapidly changing nature of this disease affect what might unfold in this space?
Well, I think that the rapidly, we've been so surprised by different twists and turns that this virus has taken. Again, highlighting the presumed specialized knowledge of scientists and not lawyers. But I would say that OSHA itself as an entity, I don't see a future for OSHA, notwithstanding this dicta that's been alluded to about particularized regulation. Well, as a matter of logic, I suppose, so I suppose, you know, as Holmes said, logic is unimportant, and maybe there are particular meatpacking type situations which could grasp this dicta in the majority opinion and serve as a basis for OSHA to intervene in the future. But I don't see OSHA as having much of a future. I don't know if there are other regulatory agencies that dispose of funds to private parties that through which similar rulemaking similar to that which the Secretary of AGW engaged in the Biden against Missouri. So I think that it's as I see it at this point, it is primarily a reliance upon exhortation and arm twisting of corporate leaders behind the scenes. I think that's going to be the primary focus.
I suspect Bill's right about this, and of course, who knows what they'll actually do. I do think there's several developments here that may take the urgent edge off of reissuing regulations. One is, I think, the different nature of Omicron as a variety is, it's really looking like everybody's, I mean, I think, didn't Dr. Fauci say everybody's going to get it? It's they're trying to stop, completely stop the transmission of this. Looks like it's, it's like King Canute trying to send back the waves. So maybe it's not worth the candle. But the other development is, I think many of us, and presumably in the administration as well, have been surprised at the pertinacity of those who aren't getting vaccinated. That, I don't know, but I kind of guess that they thought that people would just, if I have to have this to go to work, I will comply. And I think we now know that there are a lot of people who are not going to come to work, that actually care more about not getting vaccinated than they care about their jobs. And if that's so, then these regulations have some costs for the economy that I don't think were fully anticipated. They have ramifications for the supply chain. They have ramifications for healthcare. They have ramifications for the military, for the police. And so, I mean, I think next time around, if the OSHA does decide to go ahead with more particularized rules, as I think they are perfectly able to do under this, that they may be, as a policy matter, I'm not saying this is something that the courts should be thinking about, but I think the agency itself is going to ask itself, does putting people out of work for not getting vaccinated under these circumstances with Omicron, is it really on balance in the public interest?
You see, that was lost with the defeat of this case, because this was the case covering 84 million employees, where very quickly you'd get not only other corporations saying, hey, we can do this also, but there'd be less corporations, there'd be fewer corporations to which resigning workers could go to. That's lost. And I'm afraid that this case leaves us with an enormous triumph for an ignorance that I never thought possible as a child, when we were so pleased to get polio shots and diphtheria, and we thought that this was the essence of safety and civilization. That's gone, and the ability to combat ignorance in substantial part is gone.
Bernie, would you like to weigh in before we wrap up?
That's okay. Everything has been said well.
Michael, I'll turn it back over to you for any concluding remarks.
So again, thank you, Bill, for being with us. Maybe we'll have some other topics to bring you on with in the future. Bernie has been a regular on Con Law Center programs, and thank you, as always, for your participation. Thank you, Morgan, for your organizing, and most of all, thank you to the audience for your attention. The next Con Law Center program will be on February 15th, when we have a program with a very intriguing title of Structural Biases in Structural Constitutional Law. This will probably be of special interest to first-year students because so much of Con Law 1 is in fact structural constitutional law, and I think this is a really fresh, innovative take on some of those issues. So mark that on your calendars for February 15th. And thank you all.
Thank you, Michael.
Thank you.
Thank you, Morgan, Bernadette.